point that we've made at length, it's not a road, it's a
But certainly we want to have a good way for the fire truck to get in, access, do what it needs to do, and get back out. And so that was the intent of this plan, and I think it's well achieved by this plan to show how the truck has maneuverability room. And I'll note that it excludes parking spaces. So those vehicles don't need, the fire truck doesn't need areas where there will be vehicles parked in order to make that turnaround movement. The issue of will there be more folks here than the planned parking? That's, I'm sorry?
Well,
Sure. So the association, the condo association, has the ability to enforce parking rules, and if it were the board's, the board's determination, I'm going to say in this case, this board, if it had been the planning board's determination that that limitation to the parking to the spaces shown on the plan would need to be stated as part of the approval. So be it.
fully expect that to be in the regular condition of approval for any project.
any project, yep.
Again, I'm told about it.
And then again, to the comment on the degree of intersection, whether it's 90 degrees or more than 90 degrees, absolutely, it's much more. I think it's more comfortable to navigate for that emergency vehicle to navigate in the direction of sweep that is shown. So it's practically designed. But if you're going to consider that access a road, then it doesn't meet the 90 degree or within some, I think there is a variance from the 90 degree allowed up to, I think 80 degrees.
80 degrees, yeah.
But the point is, if it's not considered a road, it's a nice, big, wide swing that enhances the safety of the project, right?
So
I would love to deviate from what's written on these pages, but that's not, I don't get a vote, as I've said many times to Rick.
Yep, understood.
And again,
So-
that's what we have to look at, and
Well, I mean,
Yeah.
there is a whole section about parking on page 131 of the URO, and, it does sound to me, again, I'm not a lawyer, and I just started reading this, a couple of weeks ago, but parking areas, design standards, the planning board may require that certain areas be maintained for firefighting or other emergency purposes.
That's what we're talking about.
Yeah.
Yeah.
And I think Joel's observing that it does.
There's, to the last point of snowbanks and all of that. Oh, I'm sorry, were you done? Did I cut you off?
I'm just saying that I think that, well, maybe I misunderstood you, because I thought you had all along been saying, you got two choices, a driveway or a road, and there's nothing in the UDO about parking spaces.
That's what Mr.
Parking.
Baker thinks.
Okay. But I mean, and so it's as yet to be determined, I guess, whether any of that meets or satisfied, what the UDO
If you determine
wants
that
for
it's not
parking
if
areas.
you determine that it's not a road, okay, which I don't think is particularly hard to do, then you can say, does the ordinance say, okay, in parking areas, which is what this is, what do you consider? And that's exactly the point Joel was making, okay?
room for fire trucks, and
Yeah.
But if it's a road, it does not meet our standards.
so it comes down to definition.
Yeah.
Right, yeah.
And if it's helpful to continue in the discussion of snowbanks, snow removal is, again, planned, and also the responsibility of the association, and we've provided on site plan 2.1, I think is where it is, a generous snow storage area, which a lot of these developments don't have, though it's not for me to editorialize on that. So that's existing conditions. with this. There, so there's a generous snow storage area in here, so that those banks can be removed and put in an area where it's not going to be detrimental to the development. But all things that, what I would say is, folks like to talk about a plan or a set of plans or an application meeting an ordinance. If what's submitted meets the ordinance, the letter of the law, then the application 100% should go through as determined by the board. And it's a nice sentiment, but for those of us who prepare engineered plans and prepare applications, we know that there's gray areas. There's areas of interpretation that we undertake with the board. And so there, in any set of plans, there's going to be areas where we make calls on what do we think is the safest, what do we think is the best, the best interpretation of what the ordinance is looking for, what the community is looking for.
And the law court case law that says it's true not to create absurd results and to implement the policies of the land use ordinance in the first instance. I'd like to make an observation too that it would be a due process violation I'm hearing for someone just to say to you, hey, I think you're weak in this specific area. I was admitted to the bar in 1981, and I've been working full-time as a lawyer from then to right now. And I've done hundreds of trials, non-jury trials, ADB appeals, and a few jury trials. And in any of those cases where you're in front of a fact finder, I routinely get a judge saying, I've heard this, I've heard that, I want to hear this, okay? And I don't know if that's collaboration or just the regular give and take of how people present cases and try things. There's nothing inappropriate about a judge doing that. My wife's a retired judge, okay? She's a non-combatant now, a recovering lawyer. Okay? But the point is that all these things, it's the way you want regular disputes resolved. Okay? And so instead of this gotcha grab, all of these points, all of the very considered thoughtful points you've raised, and I've heard from Mr. Berry and Mr. Nelson, are all things that could have been done. In terms of like, okay, well, what's our core beef with John Morana's application? And with respect, whether he's a gold standard or not does have a bearing on approval process. One of the whole determinations routinely made in zoning and permitting is capacity, experience, okay, track record of violations, and then you won't find any on him. So Mr. Baker's wrong about that.
Comment again.
I appreciate the time. What was just discussed, it brought up another thing in my mind, and I'll be really vulnerable with the board. I always felt challenged by the assertion that once the application was deemed complete, that there would be no further back and forth with the board. I chose not to bring that up as an issue during those proceedings, mostly because I had faith in a process that I had seen play out many times. And I thought that deliberation was going to happen. And I think the biggest thing that I can show to demonstrate how that's confusing for an applicant is that after a finding of completeness, there was still review by the board's third-party engineer. So the board was accepting review by the third-party engineer and responses from mainland to those comments.
I think his terminology was major changes. They didn't want to
Yeah.
see major changes
Exactly.
afterwards.
So-
There's room for,
Understood, yeah.
you know, your collaboration, but
Yeah. Yeah, that, the idea that it would be completely shut off, I didn't think that was gonna be the case, because, you know, no one wants to see this come back as a restaurant instead of 3 condos, you know, that's, and the idea that would still be complete as an application is absurd, right? I'm picking something that's way off the reservation to demonstrate the point, but, the idea that there would be some tweaks to the plan in a technical nature, like might be suggested by the third-party engineer, or that might be suggested by the board, who has, you know, boards have good ideas and often find ways to improve plans. It was foreign to me that process didn't take place.
other comments? Jack?
Hi, Jack Taylor, I'm a resident. I'm actually a former planning board member myself, excuse the memory lapse here, but about 5 years. Becky was there, she might remember me. I'm in favor of this. It seems like it boils down to a matter of interpretation, and it can go either way. It's pretty sketchy that way, and I think moving forward in the years to come, Newry ought to nail that stuff down a little bit better with our town meetings, etc. We're looking at in excess of $100,000 in tax revenue generated off of this project. That's nothing to just laugh at over some semantics. When I was on the board, there were a lot of applications that came through this room, and we never turned one down. There was a lot of give and take. We worked with the applicant to make it better for the town and the applicant, so that the end result was they got their project and we were happy with how it happened. And I don't see that happening now, and it makes me sad. Thank you.
Anyone else, Mr. Baker?
I'd just like to comment that the decision is parking lot or road. What the appellant is failing to say is that the way to get to these dwellings, the way, just happens to go through a parking lot. There is no other way to these 11 dwelling units that they're proposing other than these access ways that just happen to incorporate a parking lot. They are not parking lots, they are ways. And according to that determination, by the definition of the planning in the UDRO, a way is either a driveway or a road. It's no buts about it, one or the other. Thank you.
Okay. Anyone else? Mr. Andrews? We let your wife speak, I guess we gotta let you speak.
Try and stop her.
Long walk.
I am a layman, I'm Tony Andrews, and hopefully, like you, will be a former builder. My only comment is, the term collaboration is really getting beat up here. I don't think it's a swear word. I don't think you should fill out their applications for them, but I do feel like the job and duty of a board is to act on the best behalf of the people they represent. So I think it behooves people to perhaps allow adjustments and not get all hung up on legal details that you guys can battle out and I totally don't understand. But I do feel like it requires a certain amount of common sense and looking at it like, is this project a good project for this town? Does it have detrimental aspects? Does it have positive? And in weighing those things, I think at times you're going to have some back and forth. when that gets circumvented, or appears to be circumvented, everyone digs their heels in, I don't think it's in service of the community. That would be my only take on it.
All right, thank you. Anyone else?
One of, I don't want to speak out of turn. One of the points was raised, if you comply with all of the design criteria, or it doesn't offend it, it should be approved. Well, that's the law. One of the cases that we cited there called Zappia says exactly that. If you go through the process and there's an ambiguous term in an ordinance that impairs the ability of the property owner to get approvals, that ambiguous term falls off. Tie goes to the landowner, no way looking at it.
Okay, thank you. Go ahead.
If I make 2 points. There was a finding made by the planning board, and that's finding of fact number 1, and number 2, and then a conclusion, that the hammerhead that was proposed on this was not in conformity with the ordinance. Hammerhead is necessary for the turnaround if you consider this to be a road. Now, we have a dispute there. We'll get there in a minute. The decision was made on the basis of the April 7th letter of the fire chief. At that time, the plan before the planning board did not have a hammerhead. But the night of the meeting, or in advance of that, Mainland submitted a plan and says, well, actually the whole plan set in advance of that would show the hammerhead. No one ever measured that hammerhead at the planning board level to determine whether it actually met the standard or not. And that's something that, although the CEO has talked about it this evening, it's not in the record. The planning board never did it, so there's no determination by the planning board that this hammerhead that was shown on the final plans that was submitted for consideration did or didn't meet the standard. So one could argue that you have inadequate findings and therefore would remand it to the planning board to take a look at this issue and get back to you. That presupposes that this is a road that requires a hammerhead. So let's talk about roads for a minute. If I have a lot and I put a house on it, I probably need access and frontage on a house, on a road, right? I need street frontage. I need to be able to have access. But how do I get from the road to my house? I put a driveway up to my garage. It's a driveway. Okay, suppose that instead of having a house, I have a condo in a multi-unit condo building. Well, under this ordinance, a driveway isn't going to suffice anymore because it's serving more than 2 dwelling units. What do I need? The only other access available under the UDRO is a road. So, again, I am not representing the board, the planning board, but it's been argued that the construction used by the planning board leads to an absurd result. It doesn't. I don't know if many of you've been into Rock Row in Portland, in Westbrook, actually, Rock Row. Probably shopped at Market Basket, right? You may have. If you've shopped at Market Basket, how do you get there from State Route 25, Main Street, which is the access for the whole development? On a road. It's a road built to road standards of a private road, but road standards under the Westbrook zoning ordinance and planning ordinance. Now, you could argue that's Westbrook and we're in Newry. But in Newry, you have to get there from here to the building that you're building. And it's the only 2 options under your ordinance are a driveway or a road. So if it's a road, then the road has to meet road standards. If you dead-end it at a parking lot, then there has to be a turnaround under the ordinance. It has to meet the standards for a road. There are several categories. Neighborhood road is what was looked at here. So, if you assume this is a road, and that the board was correct in determining that it either has to be a road or a driveway, or you can't get there from here. You can build a parking lot, but you can't daylight onto a public road. If you believe that's correct, then it has to meet the standards, but they did not tell you whether or not this turnaround meets the standard. So you can remand it for that, and the planning board is free to take such other action as it wishes on other evidence as it wishes, act however it deems appropriate on remand. You can put that in your order. So that's one possibility as to how to approach this. If instead you want to go down it's neither a road nor a driveway, and therefore there are no standards, that's your determination as a board. You get to look at the ordinance and how it was interpreted and applied by the planning board.
With respect to the latter point, it's not we're saying parking lots have no standards. Parking lots do have standards. They're referred to in the UDRO, okay? We meet those standards. So,
I beg to differ.
how so?
Lines, item 6.
Excuse me, Rick, can you tell me
I'll
what you
read it
just
again. It
handed
says,
out? Okay, thank you.
Where development will abut an existing or potential parking area, provision shall be made for internal vehicular connections that allow vehicles to move between parking areas and lots without having to enter the road. That's what this one does.
I don't see them connecting.
It says,
It's coming off lot 3, right? It's parking lot 3 of Sunday River,
yep,
an existing parking lot. Now the back two should connect. The planning board missed that. That would be a solution too. A
Well-
very easy one.
well, to be honest, I mean, it's not like, I was trying to find the word for the case law. It's not collaboration, but the idea is put out what your concerns are, okay?
Yeah,
That's all we're asking for.
Yeah, that's what I said in your young guy's brief. He's just looking for cooperation. in
He's
there.
smarter than I am. A lot of people are.
I don't like wasting people's time. I
Yeah.
don't know.
Right.
I mean, let's find a solution and
One more
we can
comment.
do something about it.
Go ahead.
Hi, Becky Bean. I'm actually not a resident of Newry. I live in Hanover, but I just do the planning board minutes. I'm an employee of the town. But I just wanted the talk about doing what's right for the community and such. The ordinance is what the community has voted on and passed and accepted. And that directs the planning board how to review applications. So if the planning board is upholding the ordinance, they are in essence supporting the community. Is how I see it.
I'm gonna tag off Becky on that
Go
one.
ahead.
Unfortunately, there's other fortunately, there's other boards in town that have to worry about tax assessments and what the taxes are for this town. Nowhere in the UDRO is that part of our consideration.
Bruce?
Bruce Pierce, former planning board member. I was on the planning board when this application came through, and I did the site visit. And I do remember asking because of that back lot and the whole hammerhead, and there is specific specifications for a hammerhead in the UDRO to meet the requirements of our trucks. But I had asked about, well, why don't you just make it go right up in through lot 3? And it was like, well, it'll be too difficult. And basically is what I got. So, and I didn't really push the issue, so he said.
That's a grade issue? Is that what it said?
Yes.
It's a,
Yeah, there's significant grade, although not shown on this particular plan, between the parking lots for unit 2 or building 2 and number 3. It's not impossible to connect for the purposes of passenger cars.
Again,
It
but,
will be
yeah.
difficult.
Yeah.
To have an access that's navigable by a fire truck with a fairly long wheelbase, there's potential that's either extremely difficult or impossible based on breakover grades. And I don't know the answer yet. I'd have to dig much further. So they're kind of two separate issues, right? Does the emergency vehicle have a way to get in to all sides of the building and do what it needs to do? Or is it a question of
Connecting
safety of
parking
access
lots.
of the passenger vehicles and whether or not they go through the parking lots and whatnot? There's certainly much more potential for that.
Okay. Anyone else with any comments? Can I close it for comments?
What's your agenda say?
My agenda says that at some point we have to go back to the due process.
Interesting. So you are down, you've opened up the public hearing, the applicant's been given the opportunity to
Right.
present their case, you've had a bunch of.
Rebuttal
interested-
statements have been made.
Yeah. The appellate has asked questions of us. You guys satisfied with that? All parties may refute or rebut. I think we've handled that. And the board shall receive comments and questions from all observers and interested citizens. So I think
And we've done all
we've
that.
held all of that.
Okay, but before I go to close the public hearing, we have to go back to number 5.
You can deal with that in your deliberations.
We can?
I think so.
What, are you referring to the due process?
I am. That we put off till the end.
Jim is correct. It's the parties have submitted their evidence and argument on that point. And it's for you to make a determination at this stage, it seems to me.
So do we need a motion to put that off?
You already did, you pushed it to number 5.
Right.
And so.
And number 5 is after the meeting.
It would be after the 4. So we will, I think what's in order right now would be a motion to close the public hearing if there's no further
Okay.
public comment.
Agreed.
All
I
right.
agree with that.
I'll make the motion and we've
I'll
got
second it.
second. All those in favor? Aye. This is where we are.
I see. That means we get to talk to each other, right?
Yeah, very quietly.
On TV.
You can talk to each other right out loud. I don't think there's going to be anyone interrupting. Both attorneys will correct me if that's the case.
At this point,
What?
the public has been heard and parties may speak only if asked.
Okay.
Agreed.
Oops, what's she gonna do? Okay.
Okay, so about the parking lot definition. Yeah, that takes the road thing out for a minute. Emergency vehicle access, if they could do it. I mean, they'll go in front of the planning board again. But they already know what to expect there, so. Well, maybe cooperation with both of them.
I think I have a question for the attorney, which really is, I tried to ask it earlier, it's about non-conforming situations and, you know, again, this is a unique lot in a unique spot, right? And it had non-conforming stuff, you know, nothing to do even with the lot, but the roadways, Timberline is a town road, but I guess Skiway and Southridge Road are private roads, yeah? And the access to the parking lot is private, so Newry doesn't really have, or do they? I don't know how much Newry has to say about those ways in terms of, you know, access.
Well, Newry has, it's interesting, Newry has a town road entrance ordinance that was just passed by town meeting and thought it had one before that, but had never really adopted it. But it now has, and so it requires an access if there were any
So
questions.
is it retroactive?
No.
No. So it
That was-
doesn't matter for this particular proceeding because it was adopted May 13th.
Right.
But
I
the,
mean, there's 8 days.
the
I'm not-
911 addressing thing is
That's this.
retroactive, or
No,
it
it's
is?
not.
No,
That is not.
It's not retroactive.
no.
But,
There was a site plan that was approved for this lot, for a restaurant and for an
Yeah.
office. And entrances were allowed for that use. That use has been demolished, as I understand it. It doesn't exist any further. I think that's in the materials that were submitted.
It doesn't.
One of the buildings has been demolished.
And so the planning board interpreted the situation as being a new site. And so looked at the new standards as though it was a new development on that new lot because the old approved use restaurant no longer existed. Is that correct? I mean, if you think of it this way, there is an existing plan with a curb cut on Timberline Road and 2 curb cuts on Skyline Road. This is
Skiway,
continuing.
skiway.
Skiway, I'm sorry.
Sorry, I want to get that right for the
I'll get it
record.
right eventually, sorry. On Skiway, we have 2 entrances, one of them being smaller than what had been under it's now proposed to be smaller, shorter than what was on the old use. There had not been an access from the parking lot, access 3, as part of that approved development. That is a new feature. So they're continuing what had been there. So at least it seems like access 3 looks like new to the untrained observer.
Rick wants to speak.
Yeah, I see.
Oh, okay.
Go ahead.
Are you done?
I
You done?
I mean, I can't answer you, are they grandfathered? I can't tell you for sure under the town's ordinances. That may be a call for a court if we had to go that route. The thing is, there were 3 entrances on Timberline and Skiway, and they're proposed to be retained, modified somewhat. So the question then is whether those entrances as accesses.
Well, I guess what I really want to know is, you know, there are plenty of situations where there's, oh, here's 20 acres out in the woods and we're gonna, so it's obvious what you need to do. You gotta put in a road and you gotta have driveways off the road and, that's simple and straightforward. This is a very unique situation here. And so my real question is, there seems to be, let's imagine there are 2 opposing predispositions towards what planning and URDO stuff is all about. Like, we're going to adhere to exact letter of the law and maybe reach an absurd result, or we're going to read the URDO and say we want, the intent is to provide, good access for fire and safety and, good flow and so on. And so what's the leeway for, can you grant something that is not technically not or fuzzy in terms of adhering to URDO?
There had been an access approved for a restaurant. There was some limited parking and access for a restaurant. That has been demolished, and the access being discussed now is the appropriate access for a residential development. The idea is that if you had, whatever access was there has to be upgraded to meet the new residential development need, which means it has to meet the new growth standard.
Right.
Anything, Rick?
Yeah, I apologize, I just didn't want to speak out of turn. I'm not sure if maybe it's all that relevant now that I've heard where Mr. Katsoukas was headed, but I will note that the real estate office that exists on the property still uses that lot 3 access. Actually uses it as a 2-way. Whether that's been well defined by any sort of site plan, I don't know, but I can point to, if it's all right, to go to the board. Existing conditions. admittedly, this was existing conditions as surveyed before the demo of this building. The parking does still exist. This was the large entrance and parking lot for the restaurant on the skiway road, so the big curb cut, second curb cut. But also, there was a small parking lot here for the real estate office that used this Lot 3 access. So I just wanted to clarify that.
But it's not exactly in the same location as where the access is proposed now from the back of the residential development.
No, the access point here versus
Right.
here is different, absolutely. The access to the Skiway Road from this Lot 3 way is similar.
I guess I would like to add a couple things, and I don't know if it was Tony that said the word collaboration is thrown out a lot here. We've also heard from Mr. Baker, who's the chairman of the planning board, that says the burden of proof when somebody, submits an application, it's up to you guys to understand what the ordinances say and what you should meet for criteria. I think the planning board should work with the contractors. It's the way we've gotten things done forever. But I don't think they have to lead them. I don't think they have to lead them. It isn't their responsibility to lead them through the
I
process.
agree with that, okay? I don't want to speak this. I totally agree with that, okay? No one's asking you guys to fill out, or the planning board to fill out an application. It's like the judges that I was talking about say that I need to hear evidence on this. This is a concern to me.
Mm-hmm.
That's not the same as saying I'm effectively representing somebody.
Okay, well, I think from as early as you can in the beginning, when you start listening to these, go through the process, I think they've gotten back to you with fire department letters, with the Goro report that had some roadway, and I use the term roadway because as far as I can see, that's what it is, according to the town's ordinance right now. And, it's not up to them to tell you how to solve the problem, but this is the issue we're gonna have. It's gonna be about parking and access and safety equipment and what can we do to make it better? And then it's the ball's back in your court. Go ahead.
I appreciate it. The applicant, in this case, the representative for the developer, we have a knife's edge to walk because we can take the agency letters as gospel, and we can address all of the agency letters with fire department's comments, with the road commissioner's comments, with the police chief's comments. This would be the county sheriff, if the county sheriff had comments, or the school district. There are plenty of agencies that have a chance to weigh in on this. They may have conflicting directives. And one agency's directive may conflict with another directive from another agency. They may not be the opinion of the board. So, like I go back to, we walk a knife's edge on should we address the comments from the agencies directly. And certainly we do that in narrative form. But should we alter the plans to address the agency's concerns? Or should we wait for the board to tell us which of those concerns are also their concerns? And that's, I think, the crux of what is perhaps missing.
Okay, thanks. Anything else here?
Just in case we do go to court. With the definitions, parking lot is pretty clear because it's labeled parking lot. And I don't know why the planning board didn't pick up on the number 6. But you're saying that's doable? To connect them? For
Yes.
through traffic up
It's
through the
doable
back?
to connect the back two parking lots.
Which would help on snow removal and all that stuff too.
Potentially.
Could you do it down front?
Down
You'd have to put the other, I'm sorry.
would be a little bit more difficult. I believe we'd have to shuffle, we'd get into a,
Yeah, I know there was concern with the planning board on being close to that intersection, if you could get away from that. That's not our position today, right? But there's a lot going on right there.
I would take a little exception if it's still my place to bat that around, with the idea that number 6, as you read it in the parking lot standard, means that all of the accesses to those buildings only to go through the same ingress or egress point, meaning that I would believe that that's set up to be, you have a business, there has to be a way for that traffic to get through the, from the business through the parking lot to the entrance. Not necessarily that all of this needs to be into one entrance from all sides of the building.
Well, that's not what I was saying. You could eliminate one of the entrances, the closest one to that intersection. That's a problem. Most of the time when it's ski season. Have the two lots connect in the front, come up closer to Timberline, and have more places to dump your snow right there in the front.
I can help address that. They can't get those 2 entrances, Timberline and any new parking lot. One of the findings of facts was it was already too close, so they can't get it any closer to Timberline. Section 23 talks about, non-conforming structures, uses, and lots. Trying to make this conform as much as possible.
Okay.
Not any existing lot in any town in specifically Newry, we're trying to get as much out of the resort development district as possible. And trying to get that to conform with Section 23, and every one of the findings of fact states it. This application is not in conformity with local ordinances and plans. Conversion of conformance is encouraged, and I think the planning board was trying to work towards that goal, but trying to get those 2 driveway entrances even closer than they are on the current plans, I think that would make it more non-conforming per ordinance.
On that issue, the letter that's excluded from evidence here, from Dana Bullen, says that the Sunday River is perfectly prepared to put a gate in there, right, to address.
That's the access way into parking lot 3.
We're just saying to alleviate the problem in that intersection. I know you can't submit the letter, but we could always put it on the plan if they want us to. They're putting a gate at the top so that parking lot won't empty out. And they don't want, they used to put security guards there to stop it. And now they're going to put a gate unlocked, of course, so emergency vehicles can get in. So that alleviates that huge parking lot from ever leaking that
Dumping
way.
down.
It won't leak
And
that.
only 4 units will be coming down.
Right.
But that's new evidence. You guys didn't hear any of that.
Right.
Okay.
No, I said I'm not
Right.
presenting
Yeah.
that, but if it was to be put on the plan, would that be okay? It's
Well-
an option.
As a member of this board, I don't want to dump it back down for review and end up here again. I'm just throwing out ideas.
Good
Okay?
ideas. That's what it's about.
Okay. Is that okay, Dave?
That's good.
we'll know.
Now what do we do?
I don't know. Joel?
I think I've said enough. Unless you guys have other questions for me later.
Well, we've heard both sides of multiple issues. Nobody's opinions are gonna change, nobody's definitions are gonna change. What would our board's process be if we don't come up with a decision tonight?
I'll leave that for Jim to expound upon.
At this point, the board's job is to take a look at the findings and conclusions made by the planning board. There are 4 sets of them. And as to each, you don't, the question isn't what would you do if you were in their shoes and making that anew. The question is, did the planning board make an error in how it interpreted or applied the ordinance? And were its findings supported by substantial evidence in the record? So that's it for each of those four. And if you find that there's inadequate evidence for you to make a decision, you can remand it back to the planning board with instructions to take additional evidence and to go through that criterion again.
The likelihood of further appeals to court, I think would be reduced if there was a direction of a remand. I've already stated my concern about Mr. Baker. I'm not stepping back off of that. But to consider other factors that, because you're not satisfied that the existing record demonstrates it's a road or a dead end or a parking lot, or whether it meets all these design standards, and we can consider a remand order. My preference is to have the planning board decision reversed, and then if there's a legal challenge from that by an interested party, then we can take it up in South Paris.
If you actually reverse, that means that you had enough information to make a decision.
Right.
Which is inconsistent with remanding it because there's inadequate information to make a decision.
Unless the legal grounds for reversal of this road parking lot come out, or dead end parking space come out.
So does reversal mean that the application is granted and they get their building permit or whatever?
It means that that particular decision is reversed. And so then it goes back to the planning board to make a new decision on the application.
Well, it's
on that criteria.
Right. Well, okay. If the board finds that, like for instance, on the Zappia case that I referred to, that there's a restriction, that the notion that these restrictions aren't well articulated and the tie goes to the landowner, an order of reversing would be, means what it says, that you're directed, the party, either the code enforcement officer or a lower court is directed to do something. And then in this instance, that would be to issue Mr. Murata's permits.
There are 21 standards for subdivision review. The planning board only reviewed and acted on one.
We don't have 27 separate appeals to the Town of Newry Board of Appeals, okay? The claims that have been articulated are the ones that were sprung on us after the fact. Okay?
This application hasn't been reviewed for stormwater. It hasn't been reviewed for solid waste disposal. It hasn't been reviewed for pollution. It hasn't been reviewed for any of the criteria, the other 20 criteria. And if you're going to remand it, you know, that'll have to be done as well. And so
typically what happens is you have all of the development criteria have to be satisfied. Okay. And so, our submissions, you know, no one said that we haven't, other than with respect to these specific.
No one has voted that there has to be an order approving the subdivision as to all criteria. I'm trying to suggest a path forward here if you want to remand it. There's at least one plan without findings that support the decision made by the board. That's my advice to you. That's with regard to the size of that turnaround. That would require you to concede that it's a road and it has to meet the turnaround standards. But if, you know, there was no finding that supported that turnaround didn't suffice under the planning board's ordinance. Send it down with an order to take additional evidence, make the determination, but also to allow the planning board to change its mind, to make other decisions. The planning board still hasn't looked at the other 20 criteria.
Sorry, I don't understand.
Sarah doesn't get it.
I didn't say it, Sarah said it. And she knows everything, she doesn't even understand this.
I do have a point of
Couldn't time that
order,
better.
not that we don't have anything in writing about this, but other meetings in this town run 2.5 hours, and then these three men get to make a decision whether or not you wanna run another half hour. Can we run this like we have every other meeting in town, or do we wanna make a vote, or just keep going?
Just keep going
Okay.
because other boards have rules of procedure. This board does not
Okay.
have its own bylaws. Someday you may want to have them say, no new matters after 8 o'clock.
I'll
and
be an
if you
email
want
to you
beyond-
tomorrow.
Yeah, but for right now, there are no other rules of
Okay.
procedure. You have your ordinance, you have the UDRO, neither one puts a time limit on it. It's up to you.
Go ahead.
I'm going to be bold, if I may. And
We haven't been tonight?
I'll continue to be bold, if I may.
Okay.
And suggest that if the board had issue with other standards, that they would likely have included them in the finding of fact and conclusions of law as supportive evidence as why the application was denied. It seems to me that that would be good practice for the board to have all of the reasons why the application is denied. So the bold part here for me is to suggest that you may assume as an appeals board that all other of those criteria are met and satisfied, and that we're talking about just the 4. And in that way, if you were inclined, you could reverse the decision.
One thing
That's bold.
That's bold. Well, I told you in advance I was going to be bold.
Well, you understand that under Maine's Freedom of Access Act, as well as under the subdivision law, when a planning board makes a decision, it has to come up with a finding of fact and conclusion of law on every criterion.
So they
That's
haven't done
done
that
here, because it voted that it didn't even make this one and therefore denied. And so the others are still on the table. There's no implied approval. I've never seen one, and I've been practicing in municipal law for 40 years.
But is this board allowed to completely overturn the planning board's decision?
This board is authorized to reverse the decision if it finds that there was an error of law or the findings are not supported by substantial evidence in the record. And if you don't think there's enough evidence for you to be able to make a decision, you can send it back for additional findings.
If you're persuaded by the evidence or any argument, then you can reverse it and direct that John Murat be issued his approvals.
That's my boldness.
I won't be bold. Or, like, we have the back and forth conversation with the good ideas, and we do what you're asking us to do, which is fine.
But that's not what we're looking at tonight, John. That's,
Oh, well, I thought that's what you'd said.
well, that's what he did say, but
Okay.
we're looking at this. It's not up to us to say, well, if you did this and send it back to the planning board, you get a thumbs up. I don't know that. Well, if you connected the parking lots and did all this other stuff, that's not our decision to do tonight. We're looking at each other.
You are.
I just look at the UDRO ordinance, and I look at those definitions, I read what you need to do, and to me, it's pretty black and white. And whether they make sense, whether there's common sense involved in it, I can almost guarantee you there is some that you're gonna find that there's no common sense whatsoever. But the fact of the matter is, this is what the town has spent countless hours adopting and revising,
And we will again.
and here it is.
Yep.
And there's hoops you gotta jump through, and, I listened to Mr. Baker say, yep, the burden of proof is on you guys to do what you're supposed to do according to our ordinances. And I think, maybe they didn't work with you the way they should have, or said, well, we're gonna have some issues with this. But I think the burden of proof is still on you to prove them wrong and to make sure that things are met in this thing. Is it an unusual lot? It's not one road with driveways off it. It's, it's a tight space and it's gonna be difficult, but I don't think it meets those ordinances that the town has for roadways and parking and safety access and believe me, I worked construction a lot of years and I hated the safety guys, They're a pain. But I had to abide by it or I wasn't gonna work anymore. And another thing my boss always said was that there's no such thing as common sense, John, and he told me that. He said you have to plan for the guy out there with none. You have to put it out, you have to write it down, you have to be very specific because there's no such thing as common sense. If there were, we wouldn't be sitting here today, but that's my 2 cents. And I did sit on the planning board many years ago when Powder Ridge got approved. And that was a long process. Granted, it was phase 1, I think. It wasn't the whole shebang. But we were a year plus doing that project. And, then when the owner dies in the middle of it and you gotta revamp all that stuff and, it took some time. And, you look at it today and, things are booming up there and can I pick on Becky to speak?
You do, it's up to you, yes.
Go ahead.
Can I just ask a question? I'm just wondering if the appeals board does uphold the denial, is there anything prohibiting the applicant from submitting a new application that's been adjusted to actually comply to the ordinance?
I don't know that.
Some municipalities have a rule that if there's a denial, there's a period of time that you're precluded. The town of Newry does not have that.
Right, so there's nothing that precludes you from filing a new application.
Right.
But it would be a start from scratch application again.
But I think they understand what some of the issues are. And if they wanted to protect their rights and file a suit in Superior Court, we can stay it while the planning board takes a look at it.
You can also, if there's going to be a denial, there will be an appeal in the Superior Court challenging these legal issues. But that's not incompatible with a parallel application. They can both go on at the same time.
If you want to save the time and expense, I'm sure the town would agree to put it on hold.
For what on hold?
Your complaint, just hold it while you go through the planning board process of the new application.
Depends on how strongly I like my chances on these legal arguments. I won the last time.
Go ahead.
I will note that I would hope would come into your all decision-making paradigm, that a significant amount of money goes into the preparation of an application, and while that's not your problem, a solution that might seem simple as just resubmit is probably another $20,000 operation for Mr. Mahat. So I hope this board doesn't take that lightly.
And again, the common sense part of me says that's ridiculous. You ought to be able to almost get them to vote on it and say, no, we're not gonna, allow it because we're gonna deny it because of the roadways and the parking. Okay, let me go work on that, we'll come back again. That's the common sense side of me, which again, doesn't exist, but, because it can't, but, yeah, I think the whole process is kind of foolish sometimes, but.
If we decide to remand and it just goes back to planning, is the applicant allowed to, what happens with this question of substantial changes to the plan? Like, can they mess around with the roadway, the access?
In a remand, it's
plan?
to address those points, yes.
The authority for you to remand this case back, though, is limited to additional factual findings.
Yeah, no, I understand.
But you could take additional evidence, and you could say that the planning board could look at additional materials and take additional evidence. Gives them the option.
And just as where the town doesn't have a rule that prohibits an application, and I don't see why in a remand setting that they couldn't make adjustments that they could have independently applied for. We're talking about doing economy here, so.
Does that make sense to you? Remand it back to the planning board to,
Jim, do I,
Well, yeah, you
help
got,
me.
well, there are 4 findings that are made. Which ones are you remanding and why? And on the others, are you reversing or affirming? You've got to make a decision.
okay,
So the first one is finding of fact one that it doesn't meet UDRO section 14B6. This is with regards, if it's a dead-end road, a cul-de-sac, a hammerhead has to be put on at the end of the dead end. And you've got the Newry Fire Department April 7th letter. You might say that you need additional information regarding the latest proposed hammerhead.
okay, you say we, as in this board right here.
This board might say we neither affirm nor reject this. We're remanding this one for additional information because we don't know whether the proposed hammerhead meets UDRO.
And does that allow the applicant to submit new evidence the time it goes back to the planning board?
I would say, Jim, yes, because the town doesn't have a prohibition against that process.
You would say that the planning board has the discretion to accept additional evidence or new evidence and to make findings that, on this issue or to decide differently. They denied on that basis. And you could say that or decide differently. So that's one thing you could do. The next one is with regard to frontage on 2 or more roads. The access to the lot shall be provided to the lot across the frontage and to the road where there's lesser potential for traffic congestion and for hazards to traffic and pedestrians. Talks about Skiway Road and Timberline Road. And what this says is that given the Newry Fire Department's letter, the multiple access ways do not meet the performance standards set out in UDRO 13's X3. To date, no one's really talked about this one. Did the planning board make a mistake of law? Did they misinterpret the ordinance? Did they misunderstand the ordinance? Did they misapply it? Are there facts you need to have developed in order to make a decision on that?
I believe that all can be addressed on remand.
I didn't hear you, go
I believe
ahead.
all that can be addressed on remand.
And the board has to have a reason to send it back on remand, that's all. There are findings that you need in order to get to a decision.
Seems like the hammerhead would be the easiest.
For that one though.
They'll be addressing all of them when it goes back.
You have to give reasons for each one. for
Each
them to
one of
be
the
reviewed.
4.
There's
Okay.
4, yeah.
There's what, 20 other things they have to go through too?
Well, yeah, other sections. But we're looking at 4 today.
Yeah, they have to go through the other 20, we know.
I know. I know, that's what I'm saying. It's an exit ramp for us.
Yeah.
I mean, I'm trying to make it as easy as possible for them to
Go back.
go back, not have to resubmit a whole application, fix the problems that the planning board has. You know, whether they jumped the gun and voted it down without letting them know, you know, we can argue that all night, but, you know, it's a good application, it's a good use of the property. We'll make it as easy as we can if we remand it, and, you know, if we can come up with some reasons for the other three, I mean.
We'll come up with the second one first.
Well, the first one, we have the hammerhead.
Can we make it, just to make a suggestion? Crafting order of remand, a little tricky, you know. I'm not averse to, it's John here, but I'm not averse to letting Jim Katsifikis and I take a cut at that first. We do that kind of stuff.
Mm-hmm.
And see if we can reach an agreement on terms of what our remand orders look like. And then what can be done and laid out so that there's less likelihood of procedural due process violations, notice an opportunity to be heard, and to address all the development criteria. And I think he and I can probably do that.
Jim?
That's up to the board's discretion. My thinking on this is that there were decisions made by the planning board that if you look at this, it talks about some traffic and traffic issues, but nothing's really quantified. There's no factual statements cited as to the extent of traffic issues, access issues. And if you need more information in order to be able to make a decision on this, then that would be a reason to remand it, and at the same time give the opportunity for the planning board to take more information and to come up with whatever decision it's going to.
Okay, which one of the four are you?
Well, I'm looking, for example, on the traffic counts in residential lots on Skiway and Timberline with regard to issue 2 on section 13X3A. There's a discussion about traffic congestion without explaining exactly what the problem is, without quantifying it. And you can with regard to 4 on the 3-way intersection, again, there are no traffic counts. It's just there's no source cited for the information with regard to current traffic configurations, traffic flow, and congestion. The distances that are listed in finding of fact 2, there's no source cited for those. So there's additional information that would help you perhaps to determine that. So
All I'm trying to say is that it would be challenging for a lawyer to extemporize and write all this out and make a ruling on it, put it into words that are recognizable. Okay?
So now you know where we stand.
I do.
Yeah.
I've got to appreciate it. So it's complicated.
We're trying.
I get the picture totally.
Yep.
So what I'm trying to say is that that I've got smart people. So does he. He's the young man right here. We can work this out, and I believe. And if you help, can I just? Do you do hearings by Zoom at all?
We can,
Okay.
yep.
Yeah, actually, I had a planning board hearing in Julie's case with the.
Yes,
Zoom.
but that's the problem. We only do the free access stuff, so it might be easier for you to
Oh, we can-
include us.
Well, I could definitely do that.
Okay, all right.
But in terms of.
Because it cut us off that night, didn't it?
That's true.
1 hour and you're out.
Yeah.
But the idea would be that we could figure out an order and ship it up here. And then you can convene, because you have to deliberate in public under the right to know law. And that could be by Zoom, say, what Jim and Paul said, okay, on an order of remand. That
So, yeah, going by what Jim said, we can find reasons to remand each one of these 4.
Yeah.
We don't have traffic studies, we don't, for all these
They'll
reasons.
come up with that language.
Yes,
But if you agree that that's the way you would like to go, you're telling us and we will go away and draft a proposed order. I'm not trying to make your decision for you, is the thing.
Sooner the better.
Okay.
All right, you take
You guys got
vacation
work to
time?
do, you know?
That we draft the order or go away?
Well, either or.
They're both connected, okay?
Yeah, I thought so.
I've got a,
That we want to remain.
Yes. And then we throw it into their hands to come up with an agreement, and then they'll go back to the planning board to get this agreement set and to get the other ones taken care of.
Paul and I will collaborate. How's that for a
Ooh,
word?
again,
We'll collaborate on a draft order for this board, and it would have motions that would send this back, remand for additional factual finding, but also to reopen on this issue of traffic. Suggestion, while it's going back for traffic, maybe they ought to make findings on all the other criteria so that it all gets done.
can we talk to Mr. Baker right now about, were you willing, to kind of do that?
That's not, I don't think that's appropriate right now.
No, I-
Okay.
Yeah,
Okay.
But just, I'm suggesting, let's get this all taken care of at one time.
oh, no, I agree with that. I mean, the irony is that if the permits have been issued and there've been no objection from anybody, and all of those other findings, in fact, the approval order would be unassailable, okay? And now because of this situation, we're gonna be going all the way back and doing it all over again, okay? It really isn't fair, but he and I we can draft up a remand order.
When does this board want to meet again to talk about this? Assume the room is booked.
Well, you guys are the ones that are gonna draft this thing.
Well, we will, but tell us what, lawyers only work under deadlines.
So tomorrow at 5 o'clock,
There we go.
I'm not available.
I've
You know.
I've got another one of these on Monday in South Portland.
Can't use this room
Oh,
on
yes.
Monday.
So, we can do it,
30th,
yeah. 30th of
What's the
July.
30th fall on?
Wednesday,
Okay.
and I'm doing Wednesday. Is it gonna be a personal meeting, or is it gonna be a Zoom meeting?
Like an act of mercy, so I have to
Yeah.
drive up there.
Yeah.
But we're gonna do it by Zoom.
It's a beautiful area.
Well, we're going to Bethlehem
I
tonight.
know, that's right. So
The board has to
we'll
meet
you
in
there.
person. It'll be what we call a hybrid meeting where the
Right.
board is here and then some members are attending by
Yeah.
remotely.
Okay,
And we can attend remotely as well. Any luck, we'll resolve all the issues, so it should be a short meeting.
okay, July 30th, Wednesday, July 30th.
What time would the board like to meet? Is 5 good again?
That's fine.
That's fine.
Okay, 5 PM.
I thought we were in control of that.
I wanna make it as easy as I
Five's good.
can for everyone, I really do.
Do we have to vote on this?
Well, we haven't made a motion yet
You've made
to,
motions yet.
Okay.
right, we're gonna make a motion to reprimand the 4.
No reprimand.
To
Remand.
review.
We'll
Remand.
make a motion when we have it drafted. For now, it's to
Okay.
continue the meeting
Yeah.
to July 30th at 5 PM.
Okay, continue the meeting.
Continue this meeting, and and council have been directed to collaborate on a proposed order for the board to review and we hope adopt at that time.
So noted.
Yeah, that collaboration will continue to preserve our legal arguments about the road dead end
That's
situation.
what you guys are talking about.
Yes.
Well, I don't know that Paul and I are going to resolve that set of
I
arguments.
hear there's an alley between the two offices. You guys go meet.
Rock, paper, scissors.
Yeah.
Forming alley.
So,
Okay,
so that was a motion?
Yeah,
yes,
I second that motion.
okay, all in favor?
Continuing.
Aye.
Okay, we'll continue the meeting July 30th.
Great.
5 PM. You'll have all your stuff done and
yeah.
no black eyes.
We've done a lot of these, still
Thank
going
you.
really well.
Now you're gonna say adjourn.
Oh, okay, I make a motion, we adjourn.
Yes, I second that motion, for sure.
All those in favor?
Aye. Aye. Okay,
Thank you, guys.
Holy smokes.
this is what we do.
Yeah, right.